Well, good morning. My name is Jeff Stauffer, Community Relations Director with Elville and Associates, and welcome to our webinar today, Estate Planning for the Surviving Spouse, Considerations, Recommendations, and Procedures. We have our presenter today, Partner and Senior Estate Planning Attorney Olivia Holcomb-Volke with Elville and Associates, so welcome. I'll say that our clients think the world of Olivia because of her extensive experience and the time that she takes with her clients. And of all the attorneys that I could have chosen to work with a few years ago when my family and I did our planning along with my mom after my dad passed, we all chose Olivia to work with. So I think that says something right there as far as what I think of Olivia personally and on a professional level as well. So briefly, the way this will work today, if you're not familiar with our webinar series, is you as the attendees are on mute. However, you do have a voice. There is a box on the right of your screen where you can ask questions and interact with me throughout the presentation as the moderator. And we'll pause to field those questions throughout as well as at the end too. For certified financial planners, CPAs, and other professionals on today's webinar, which there are some, welcome. You may receive 1.5 continuing education hours for attending. And if I don't have it already for my records, I do need you to please email me your board ID, and also for certified financial planners, I need the last 4 digits of your social security number. So please go ahead and send that my way if I don't already have it on file. Everyone will also receive a survey immediately after the presentation. So we ask that you please just take 2 minutes to fill this simple survey out. It offers us really valuable feedback about how we did. It gives you a chance to share with us some feedback about some ideas that you may have for a future webinar, which we're always looking for. And also it gives you an opportunity to request a time to speak with Olivia about your family's planning needs, and there's nobody better, in my opinion, to speak with Olivia about your personal needs as far as planning goes. So just a little bit about the firm, briefly, if you're not familiar with us. We were founded in 2010 in Columbia by Principal and Lead Attorney Stephen Elville. We have a number of practice areas here at the firm and services, including estate and special needs planning, elder law and elder care planning, estate and trust administration, along with asset protection, guardianship, and a busy litigation department, as well as tax planning. We have 6 attorneys, 13 staff members in 5 locations, and a mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. And we focus on education a lot here at the firm, and that's through our planning processes with our clients. Again, we offer well over 100 educational workshops and webinars in the communities we serve each year, and also by way of our accredited client care program. We're the only firm in the state of Maryland, I should say, that's been accredited by the Client Care Academy in Boston through our client care program, which we're very proud of and offers a lot of great benefits that many of our clients take advantage of. We always work here at Elville and Associates with the ideals of client education, collaboration, and compassion in mind with every client, every time. So you should expect nothing less anytime that you work or partner with us, or with any company for that matter. So hold us to that standard every time that you interact with us. A little bit about Olivia. There's a lot to share, but just some of her highlights. Olivia's work is centered in estate planning, elder law, estate and trust administration, special needs planning, and asset protection. Very seasoned speaker, presents at numerous workshops and continuing education events and conferences. Named to the Maryland Rising Stars list by Maryland Super Lawyers. Named 10 best for client satisfaction in estate planning by the American Institute of Legal Counsel. We are very proud of Olivia's volunteer work at Elville and Associates. She is a board member of the Women's Law Center of Maryland, as well as the chair of the Judicial Selections Committee for the Women's Law Center. She is also a volunteer attorney for the Maryland Volunteer Lawyers Service, a founding member of the Community Advocacy Network of the MVLS, named Volunteer Lawyer of the Month for the MVLS in last May 2019. And she also provides training to volunteer attorneys on advanced directives, financial powers of attorney, wills, and deeds. So very proud of her volunteer work, and she gives a lot to the communities that she serves throughout Central Maryland. So you're in good hands with Olivia today, and really looking forward to listening to her presentation. This is the first time we've offered this webinar here at Elvil Associates, and I think you'll get a lot out of it. So what we're going to do right now is start off with just a brief poll, just to get an idea of who you are as the audience, and it is completely anonymous, so don't be shy in participating. So the question for today is, as an attendee of today's webinar, what is your main purpose for gaining education today? And I've just launched that poll. Should be launching. Click on that. There we go. And your choices are, I'm currently a surviving spouse looking for guidance. The second option is, I'm seeking knowledge for the future. Third, I have a friend in need that is a surviving spouse. Or lastly, I'm an advisor seeking knowledge to better serve my clients. So if you can just note your best choice there, gives us an idea of who our audience is today, and then I'll turn it over to Olivia. All right, we have about 3/4 of everybody voting so far, casting their thoughts here. Okay, so most people having cast their responses. We have 4% saying, I'm currently a surviving spouse looking for guidance. 54% saying, I'm seeking knowledge for the future. Nobody's saying that they have a friend in need. And 43% saying, I'm an advisor seeking knowledge to better serve my clients. So great to see. Thank you for participating. We appreciate feedback. So I'm going to go ahead and turn the presentation over to the capable hands of Olivia, which just requires me to click a couple buttons, and she'll have control of the screen there in just a minute. And I will get my camera off of the screen here so I'm not a distraction. And it is all yours, Olivia.
Excellent. Thank you so much, Jeff. Good morning, everyone, on this rather gloomy Tuesday. I'm delighted that you've joined us for my presentation on estate planning with a specific focus on the surviving spouse and the considerations and approaches that are all part of that conversation when thinking about the reality of a surviving spouse and planning for that eventuality. Bear with me as I get my technology to work. So inherent in the term surviving spouse is the idea that there were once two individuals involved. Two individuals who were involved in the actual accrual of assets, and two individuals involved in the contemplation and decision-making with regard to the distribution of those assets at death. As I go through this presentation, there are two perspectives, and of course, I will do my best to emphasize what the perspective is from both angles, but as we're going through this, it's a matter of the perspective from a married couple when both spouses are still alive, and then the perspective from the actual surviving spouse after the other spouse has passed away. The considerations that are the most relevant when we're talking about estate planning with regard to the eventuality or the current existence of a surviving spouse really pivot around remarriage, asset protection, and tax planning. And those are the three considerations that I'll spend time on today, because those are the three most relevant considerations when we're doing estate planning in terms of a surviving spouse. The first one is with regard to remarriage. And I always chuckle a little bit at this, because when I'm working with a married couple and both spouses are present and they both say, when I bring up the reality of remarriage being a possibility, and they both look at each other and they laugh and they swear, never again. Well, I'm here to tell you, even if that is how you feel, and even if that is what you say, statistics show that remarriage happens more often than not. And this is also a relevant consideration, even if the deceased spouse swore, "I'll haunt you." Even then, remarriage happens frequently and is something that is worth contemplating the considerations and the relevance with regard to estate planning. So one of the things that I want to talk about is what's called the elective share. And this is something that I always want to introduce people to the existence of this reality in the statutes of Maryland. And the reason that this is such an important thing to be aware of is that it is a very common assumption. Everyone is equally guilty of believing this, and I was too, until I actually started practicing in this area of law. The idea that you have full control over dictating where your estate goes at your death, that is a common assumption. My estate, I get to decide where it goes at my death. The statutes do not agree with you. The elective share is actually something in the law of Maryland that guarantees that a spouse has rights to a portion of the deceased spouse's estate. So again, even if a spouse has a will or has a trust or has their estate set up in such a way that they've got documents in place saying, at death, I want my estate to go to these people or these places. If those documents do not provide for a certain percentage of the estate to go to the surviving spouse can actually rely upon the statutes of Maryland to overrule the documents that their deceased spouse had in place and actually elect to take their statutory spousal share. This is important to be aware of. If you are a married couple and you are working on your estate plan and you're contemplating the fact that one of you may die before the other, the fact that the surviving spouse may get remarried, and in fact, more often than not, does, it's important for you to be aware that a new spouse who was not part of maybe your original family, obviously, but with regard to maybe the children that you have with your current spouse, a new spouse coming in later on might have the ability and might in fact elect to overrule your surviving spouse's plan. If your surviving spouse plans to leave everything to your children, but they get remarried, that new spouse may actually be able to overrule that plan. So that's something important to think about when you're a married couple planning for a future where one of you may die before the other. It's important to be aware of the existence of what's called the elective share, because a remarriage and a new spouse could end up impacting your joint plan with your current spouse with regard to where your joint estate will ultimately go when both of you have passed away. And if you are a surviving spouse, I want you to be aware of the reality of the elective share, because if you get remarried, I want you to know that the elective share is something that exists in the law. And even if you have a will or a trust or an estate document that says you're leaving everything to your children from your first marriage, if you die before your new spouse could override that plan. So it's just an important thing to be aware of so that you can take it into account as part of your planning, because there are certain things that can be done. It just requires careful planning. And I find more often than not, people are completely surprised to hear this. Elective share is a part of the law. So then that leads to pre and post nuptial agreements. I would emphasize to everyone, whether it is your first marriage or your second marriage or beyond, everyone would really benefit from having a pre or a post-nuptial agreement in place. Now, a prenuptial agreement is stronger than a post-nuptial agreement, but a post-nuptial agreement is still a very good contract to have in place. People often think of pre- and post-nuptial agreements as relevant to divorce. That is true, but they also have relevance with regard to estate planning. And the relevance that they have with regard to estate planning is that it's an agreement, a contract between spouses that allows each spouse to say, I get to plan for my estate, and you, spouse, will not override that. So there's a good example of how you can make sure that the elective share won't be utilized to disregard the estate plan that you put into place. By having a pre or a postnuptial agreement, part of the agreement covers my right to do an estate plan as I want to, and you, my spouse, cannot override it. So a pre or a postnuptial agreement is important. If you're currently married, it's a good idea. If you're the surviving spouse, I urge you that before you ever get remarried, this is extra important, because if you and your deceased spouse had agreed and understood that you would have a certain plan for your joint estate and maybe for the children from your marriage, if you're going to get remarried, I highly recommend that you do a prenuptial agreement in order to make sure that you protect your ability to plan for the estate the way that you intended, rather than having it be open to the risk, yes, of divorce, but also open to the risk of your new spouse being able to override your estate plan. Irrevocable trusts are an option for how we might plan for the deceased spouse's estate to be used for the benefit of the surviving spouse, but to not be available for the surviving spouse to give away to a new spouse, or to have a new spouse be able to take. So irrevocable trust planning is one of the devices that we have available in order to make sure that the plan that exists between a married couple will in fact succeed, even if one of them dies before the other and the surviving spouse gets remarried or just makes different decisions. Part of the way that we can really guarantee as much as possible that the meeting of the minds between the two spouses will succeed and carry on even if one of them dies before the other involves irrevocable trust planning. And another option, always just part of the conversation, and that's why I call these considerations, because not all of this is going to be relevant to everyone. And the reality with all of this is it's a matter of weighing the risks. So it's always a cost-benefit analysis to determine what are your personal goals, what are your personal worries, what are the other circumstances and factors that are personal to you and your marriage and your estate and your family. We take all of that into account, and of course also the assets that we're actually planning for. All of that is part of the conversation, but these are just important considerations to add to that conversation. But an additional planning tool that we sometimes implement when we're talking about what is it that you want to make sure will happen with the estate, and in the event the surviving spouse gets remarried, how do we guarantee as much as we possibly can that your intentions will be carried out and not perhaps ruined or overruled by later decisions by your surviving spouse? And sometimes that means that the best plan is to skip the surviving spouse. Now, I don't mean skip the surviving spouse as to 100%. I simply mean that if it's important to you to make sure that this item or this dollar amount definitely goes to your children or your grandchildren or whomever, part of the plan may be that we do that immediately upon your death, and then the remainder goes to your surviving spouse. But in that way, we've made sure that if your surviving spouse changes their mind or gets remarried or changes the plan, that you've ensured that at least the things that were the most important to you happened right off the bat. But again, all of this is a matter of playing a role in the conversation and determining the best approach for you. Another consideration to take into account when we're talking about estate planning with regard to a surviving spouse is asset protection. So with regard to asset protection, what we're talking about is protecting assets, usually against the risk of creditors, and that includes against the risk of divorce from a future marriage. So asset protection planning is part of the conversation, and the options that we typically talk through all pivot on some sort of irrevocable trust planning to hold the estate of the deceased spouse for the benefit of the surviving spouse. The different types of irrevocable trusts that really play a role are called a marital trust, sometimes referred to as a Q-tip. This is a type of trust where the only beneficiary of the trust is the surviving spouse. Another type of irrevocable trust that's sometimes implemented for the sake of asset protection is called a bypass or credit shelter trust. This is sometimes referred to as a family trust, and that's because it is allowable for the surviving spouse and others to be the beneficiaries. So with the marital Q-tip trust, the only beneficiary allowed is the surviving spouse. But with a bypass or credit shelter or family trust, it can be the surviving spouse and additional people, typically descendants or other family members. Sometimes a supplemental needs trust is the right plan, and this is something that is a type of irrevocable trust that holds assets for the benefit of the beneficiary, but that the beneficiary themselves has no control over and has no rights to demand money out of it. This is typically used for the purpose of protecting assets for the benefit of someone while still protecting their eligibility for government benefits that are dependent upon their available resources. Sometimes when we're doing estate planning and a spouse maybe is disabled or has other health challenges, where we're concerned about the need to use assets in the future and the potential need to receive government benefits, supplemental needs trust planning may be the right answer and play a role in the conversation. But these are three types of trusts where they are irrevocable. They have different elements to how they're composed and the terms of how they function. But by having these irrevocable trusts as part of the plan, what you're doing is setting up a plan where you're planning for how the surviving spouse can still benefit from the deceased spouse's estate, but putting into place some parameters that provide protection for the surviving spouse against creditors, but also against remarriage and the ability of a new spouse to claim or elect their elective share or otherwise make demands or assert any sort of rights over the assets in these irrevocable trusts. So asset protection covers both creditors and the possibility of divorce and the elective share. So these three types of trusts should always be part of the conversation. There are pros and cons, as with everything, and that's why there is no one answer for everyone. If you are the surviving spouse, and if you are the beneficiary of any of these particular types of trusts, part of what I want you to know from this presentation is that there are good reasons for those trusts, and to not try to liquidate them or otherwise disregard the existence of these trusts because they do serve really important purposes. So I, again, would just always recommend having the conversation with me to determine the best path forward. And if you are the surviving spouse and you maybe haven't done anything to deal with your deceased spouse's estate, often, and again, this is an understandable reality, it really is, but frequently when a spouse dies, first of all, there should always be the time taken to grieve. I never want people to feel that they need to immediately contact me or immediately contact their financial advisor to immediately do anything. Give yourself a moment to grieve. But before too long, I do recommend that we look at what the estate plan is and what the documents were that were put into place, and that we do actually do the work to administer your deceased spouse's estate according to the documents in place, because it may well be that these types of trusts are supposed to come into existence at that point in time, and they do serve good purposes. So it's best not to disregard them. And so I welcome that as part of a conversation with you. One last thing I will mention with regard to asset protection is in terms of retirement assets. And specifically here, I'm really meaning 401k, IRA, 403b, TSP, those types of retirement assets. So it is allowed under the Internal Revenue Code, it is allowed that if you leave those types of assets to your surviving spouse outright, they are able to do what's called a rollover. And in doing so, that retirement asset actually becomes theirs. And you may or may not know this, but those types of retirement assets, if they are yours, not inherited, and that gets a little confusing, I'll talk a little bit more about that, but if they are yours, they are asset protected against your creditors. And I do need to say a caveat to the term protected against your creditors. There are certain creditors called super creditors who do have the ability to access funds that are in trusts or retirement assets. For example, the IRS. So when I say creditor protected, I always want to put an asterisk to say I don't mean against every single possible creditor, but most. So with retirement assets, if they are yours alone, yours personally, they are protected against most of your creditors. A surviving spouse who inherits as the primary beneficiary on the retirement assets can roll them over. Now they are considered the assets of the surviving spouse personally, and they also have that asset protection against most creditors. That is not an applicable statement for anyone else inheriting retirement assets. It is only applicable to a surviving spouse. But with that, you do have asset protection. So you can plan for asset protection for your surviving spouse by leaving them your retirement assets. And if you are the surviving spouse and you did inherit retirement assets, understand that you do have asset protection in that. However, that does not protect against the risks of remarriage. So it should still be part of the conversation. Jeff, I'll pause here. Are there questions so far?
Olivia, you are reading my mind because I was just going to interject and say, could I ask you a few questions? So yes, first question is, how common is the elective share across the country?
It is very common. I can't tell you the exact number of states, but I suspect probably every state has it, but the majority certainly do. And the basis for the elective share, people are often affronted at the existence of it, but there is a good basis for it. And the basis for it is you shouldn't be able to disinherit your spouse. That's really the basis. And the origin of that public policy approach was when one spouse was frequently accruing most of the assets and the other spouse was frequently doing the work of the household, it would have left the spouse that did the work of the household reliant on government benefits if the spouse who could accrue all the assets left them to someone else. So that was the origin of the elective share law. It is based in public policy, but it is an important thing to be aware of because, again, it's not something that most people realize is an applicable law.
Okay, another question, and I think an interesting question. Would a pre or post-nuptial agreement eliminate the new spouse's elective share?
That's exactly right. That's exactly right. So by signing that pre or post-nuptial agreement with a new spouse, either a soon-to-be new spouse or a current new spouse, part of that pre or post-nuptial agreement is that you each are agreeing, I can do whatever I want with my estate, and you will not assert your elective share against it. Or if you do, you will not succeed because you signed an agreement saying, I can plan for my estate how I want to. And if I choose to leave my estate to you, new spouse, or part of my estate to you, new spouse, I have the right to do that. But if I don't do that, you don't get to assert rights against what I've done. So that's exactly what part of it is that it protects against the risk of the elective share.
Okay, that's actually it for right now. So everybody feel free to continue to pose those questions and we'll go ahead and address them. Thank you, Olivia.
Thank you, Jeff. So then we have, of course, everyone's favorite topic, which is taxes. And really what I think all of us can agree to is that I have yet to have a conversation with anyone who is not interested in talking about how to minimize or avoid taxes. And this is a relevant part of the conversation when we're talking about planning for a future where there may be a surviving spouse, and then from the perspective of actually being the surviving spouse, and how does all of this play out? And in terms of estate planning, the taxes that we're really talking about, and particularly with regard to estate planning for a married couple for the eventuality of a surviving spouse, and then for the surviving spouse, the taxes that we're really talking about are estate tax and income tax. So what I've covered so far, and with regard to the planning techniques that we have available, particularly with regard to those irrevocable trusts, part of the conversation and part of the pros and cons have to do with how does estate tax play a role in this, and how does income tax play a role in this. And so, as I said before, there is no one answer for everyone. There is no golden ticket where you have all of the pros and none of the cons. It's a matter of figuring out what is the combination of pros and cons that are right for you and your assets and your goals and your family and your concerns. So with estate tax, it's really a matter of figuring out what exposure does our joint estate have to estate tax, or what exposure does the surviving spouse now have to estate tax, and what sort of plan can we put into place that would minimize that exposure or ideally avoid it completely. But then there's the relevant topic of income tax, which also plays a role in it, and particularly with regard to planning for a surviving spouse and thinking in terms of implementing some sort of irrevocable trust planning in the event of a surviving spouse. There are different income tax consequences. And when I say income tax, I want you to know that that phrase includes considerations of capital gains and steps up or steps down, but more often we're worried about steps up in basis. So income tax planning is part of the conversation because there are different income tax and capital gain consequences depending upon the type of irrevocable trust that's put into place and the types of assets that we're planning for. And that's also relevant with regard to inheriting retirement assets, is contemplating the income tax consequences on those retirement assets that have not yet been taxed. So tax planning, when we're talking about a married couple or a surviving spouse, what we're really talking about is estate tax planning and income tax planning. And really, the thing that I always want to emphasize is that if you are the surviving spouse, it is important to review and revisit and update the estate plan, because the plan that was put into place needs to be, number one, reviewed to make sure that if there is anything that needs to be done following the death of the first spouse, that it is taken care of, because there are certain tax filings that have to be done within a certain amount of time. Now, remember I said, don't feel like you need to contact me or your attorney or your financial advisor necessarily the next day. Give yourself a moment to grieve. But there are things that are important that if they aren't taken care of within a certain amount of time, they're either lost forever or other negative consequences can result. So typically it's something where you do have at least a few months, but it is a good idea to review, revisit, and update in consultation with me or your attorney and your financial advisor to make sure that anything that needs to be done is done, and to revisit your own estate plan at that point in time, because obviously now things have changed pretty significantly. So reviewing and revisiting and updating is a really important part of, if you are the surviving spouse, give yourself a moment to grieve, and then let's review, revisit, and update. This is also an important rule of thumb, even if you're a married couple and both spouses are still alive. Don't think of your estate plan as something that is a one-time thing. Do it and then revisit it and update it. I tell people a good rule of thumb is about every 5 years. That's just an easy number to keep in mind. About every 5 years, I need to revisit and update my estate plan. More often if you have significant changes, obviously, but at least every 5 years, it's vital to review and revisit it because your intentions may have changed, your goals and concerns may have changed, your assets most certainly have changed, and the only way that you're able to make certain that your estate plan will be ready to go at the moment in time it's necessary is if you do review and revisit and update it regularly. So I'll pause again, Jeff. Any further questions for the moment?
Not at this time, Olivia. So you can continue.
Okay, so I'm going to shift gears now into a brief review of what estate planning really means. So estate planning is not only what happens to my stuff when I die. Estate planning also covers planning for the risk that you may still be alive but become incapacitated. So in that circumstance, who is it and how will someone be able to take care of your healthcare decision making and to manage your finances and pay your bills for you from your assets and file your tax returns for you and all of the things that are necessary with regard to assets of any kind in the event that you're still alive but incapacitated. And of course, estate planning then also includes planning for how your property will be disposed of at death and making sure, and this is relevant very much with regard to a surviving spouse, how to make sure that what happens at your death will guarantee the protection and care of those who are dependent upon you, or with regard to someone that you have a joint plan, how do you want that to be carried out in the event that there's only one of you remaining? Incapacity planning, the important point about incapacity planning for everyone to understand is that it's really about avoiding guardianship. Guardianship is something that many people think of with regard to minors, so they're young children, that they need to make sure that they've signed a will or necessary document designating the guardian of their minor children if they were to die while their children were still under the age of 18. That is one version of guardianship, but there is another version of guardianship called adult guardianship. And that is really what we're trying to avoid by doing these important incapacity planning documents. So in the event an adult, someone over the age of 18, loses their mental capacity and is no longer able to manage things for themselves, if they have not signed documents giving another person the authority to act on their behalf, unfortunately, that often leads to the court getting involved and a guardian being appointed by the court, and the guardian is now in charge of the incapacitated adult's healthcare decision-making and financial decision-making. And the guardian is supervised by the court and has to check in with the court. The whole thing is embarrassing and expensive, and it opens the door to litigation, none of which are things that anyone who has mental capacity wants to ever happen to them. So the best way that you can protect yourself against that risk is by making sure that you have these documents in place. The Advanced Medical Directive and something called the MOLST, which is a little bit different, and I'll talk about why, and powers of attorney, which cover the financial aspect of things. And I want to emphasize that these are relevant and important and necessary, even if you are married, because it is not actually guaranteed under the law that your spouse has the right to do all of this for you in the event that you are incapacitated. If you don't have documents actually designating your spouse as the person who has that authority, they actually they are not guaranteed to be able to do so. So being married does not prevent you from needing to do these important documents. So the Advanced Medical Directive is sometimes known as a healthcare power of attorney. It is the document that covers healthcare decision-making. It is the document that allows you to appoint agents, which means this is the person who I am empowering with the ability to decide what healthcare treatment I may or may not receive, where I may receive it, and to really be my voice to doctors and other healthcare providers. It also allows you to designate at what point your agent has that power. And I know that seems like a silly consideration because obviously you don't want someone to be able to speak for you if you are capable of speaking for yourself. That is not what effectiveness of power means. No one should or will be able to speak for you if you're capable of speaking for yourself. In the document, what it's really talking about is what level of proof do you want your agent to have to provide before they would be able to be your voice to the doctors and healthcare providers. And that's all part of the discussion that I have with clients, the nuances that are involved in that decision making. The Advanced Medical Directive also includes the portion of the document that's called the living will. This is a term that people are usually familiar with, at least the term. They don't always know what it means. There's frequently a lot of confusion between a living will and a last will and testament. They are two different things. The living will is a portion of the Advanced Medical Directive where you are actually giving specific treatment instructions regarding treatment that you would want to receive if you were in certain end-of-life situations. So the living will is you giving your treatment instructions for if you are still alive, but considered to be in an end-of-life situation. The Advanced Medical Directive also allows you to go into some detail about personal preferences like food and entertainment and who you would want to visit and all of that sort of thing. It does allow you to designate whether your healthcare agent absolutely must follow your instructions and has no discretion, or whether you are giving them discretion, but that they are to follow your instructions unless healthcare providers guide them that something else might be in your best interest. Organ donation and final arrangement instructions are also part of the document. And this is how Maryland has set up its healthcare document. As I say, other states refer to it as a healthcare power of attorney. Some states do it as two separate documents, the healthcare power of attorney, and separate from that is the living will. But Maryland's document is called the Advanced Directive, and it incorporates both elements in one document. What it does not cover is what's called DNR, and that's something many people, again, are familiar with that term, and they ask me, does this cover my do not resuscitate preferences? And the answer is no. That is actually something that's covered in a different document. In Maryland, that document is called MOLST, which is the Medical Order for Life-Sustaining Treatment. In other states, some other states, it's called POLST, which is Physician's Order for Life-Sustaining Treatment. Hear me when I say medical order or physician's order, because it is actually a doctor's order that is signed by a doctor. You don't sign the MOLST form itself. But what you are able to do is actually fill out something called the Healthcare Decision-Making Worksheet. And that is a document where you are able to complete it to instruct a future doctor who may need to fill out a MOLST for you, that the Healthcare Decision-Making Worksheet helps guide them on how you want them to fill it out. Do you want to be resuscitated? what are the particular circumstances that you want to be in place with regard to that order? And that's something that I usually recommend that people discuss with their primary care physician, because that really falls more within the purview of the medical healthcare industry rather than the legal industry. But it is important for people to know that the DNR is not covered by the Advanced Medical Directive. Jeff, questions?
I apologize, I had to unmute myself. So we have a couple. There was one rather lengthy question. If you perhaps check your chat box at the very bottom, that might be blinking orange. I did forward it to you so you could see it. Do you see that question? I can read it, and also sent it to our audience so they could see it as well. You see where I did that, Olivia?
I think so.
Okay, so I'll go ahead and read it. The question is, scenarios of survival, but not given outright to other spouse as trustee, and does a revocable living trust ID very specific instructions as to desired management and drawdown? Best to not have spouse revocable living trust trustee when assets would go to my children in case we both never had to use assets. Non-family trustee assurance. So there's a few topics there that the gentleman was trying to address.
Sure, and so thank you for that question. And all of that is part of the conversation that you should have with me or your estate planning attorney, because those are all relevant considerations. So the idea of, number one, not having an estate go outright to a surviving spouse, but instead doing some sort of trust planning, that's part of the conversation. The pros and cons, your particular assets and concerns and plans, all of that. So that's part of the initial conversation. Beyond that is then the conversation of, if you do want to implement some sort of irrevocable trust that will hold the assets of the deceased spouse for the benefit of the surviving spouse, what do you want the terms of that irrevocable trust to be? And we can customize and fine tune that to a certain extent. So there are certain elements of an irrevocable trust for the benefit of a surviving spouse. There are certain aspects of it that we cannot plan around what's required by law. So there are differences between the marital Q-tip trust and what's allowed legally for that to qualify as that type of trust versus a bypass credit shelter family trust. There are aspects of those types of trusts, and certainly with regard to a supplemental needs trust, there are certain aspects of those trusts that we cannot do as you wish in violation of what's required by the law. But to a great extent, we can certainly customize the terms of how the trust assets would be handled and used in accordance with your specific instructions and desires. And then it leads to the conversation about whether or not to have the surviving spouse be the trustee and the considerations that go into that. Quite simply, if the surviving spouse is the trustee, they won't have to ask anyone else for permission to take certain actions or distribute certain monies, and that can be good and bad. And that's part of the conversation as well, because it depends on what is the highest priority with regard to the plan. And so again, not everyone has the same highest priority. It's a matter of talking about it, the pros and cons behind having the surviving spouse be the trustee versus having someone independent be the trustee versus having a professional be the trustee. Each of those come with their own pros and their own cons. And it's a matter of just talking through with the specific clients as to what is their top priority, and out of that combination of pros and cons, which one resonates with them. And then let's see. So go ahead, Jeff.
Yes. So the other question we have is, if I pass away and the paramedics arrive, is the MOLST form the form to give them to avoid resuscitation?
So thank you for that question. And what I would say about that is I recommend talking with your physician about that question, because they will be better able to answer how it actually works. My knowledge of the MOLST is that there are certain medical situations in which the MOLST has to be signed by a doctor and part of your, attached to the clipboard at the foot of the bed, or otherwise part of your medical file, so that if you're in certain medical situations, such as in a rehab facility for more than a certain amount of time, that if you code in that situation, they will already have the medical order already in place to know what to do. It's a little bit more complicated when we're talking about paramedics showing up at your house or anywhere. That's a little bit more complicated because, number one, there's the aspect of the emergency element that's involved. And number two, the access to the forms. So I recommend that you talk with your doctor about that question. It's an excellent question, but I do not know the answer to it. Jeff, I actually see another thing in this chat box. Can second marriage assets be protected and directed to self and spousal support scenarios of survival, but not given outright to other spouse as trustee?
I believe that is the same, another part of the same question that was
Gotcha.
just answered by you, Olivia.
Okay.
Yeah. So let me double check. I think those are all the questions we have for right now.
Okay. All right. So healthcare decision-making is covered by the Advanced Medical Directive, and importantly, the DNR is covered by the MOLST. And I'll say one last thing about the MOLST. Again, the person that would be able to give the best guidance is your physician. But we, Elville and Associates, and Maryland at large, there is excellent literature on MOLST. And we have that we provide to clients, that we're happy to provide to any of you. And it's both a sample of the healthcare decision-making worksheet, a sample of the actual MOLST form, and literature to help hopefully answer some more detailed questions about when is the most relevant, how is it relevant, how is it really used, all of that. There's literature that covers that, but I always recommend that it be a conversation that you have with your doctor. So then for the financial aspect of things, while you're alive, if you're incapacitated, we want to make sure that you have financial powers of attorney in place in order to protect you against the risk of guardianship. The financial powers of attorney that we provide to clients are twofold. And the two documents that we utilize, they don't replace each other. They don't revoke each other. They work together. And the reason that we do both of them, I'll try to say it in an understandable way. 1A is the Maryland statutory form. The reason that we utilize this form is because it comes directly out of Maryland law. The legislature created it. And in Maryland law, it says if you use this form and you don't change the language other than a few small details, such as the people that you're actually giving the power to, and the effectiveness, which means when is their power effective, but otherwise, if you leave the language exactly as it's written in the statutory form, Maryland law says it's mandatory that financial institutions accept this document. And that's why we always want to use this document as the starting point, because it has the power of the mandatory acceptance behind it. But the reason that we use what I refer to as 1B, which is the title of it is General Durable Financial Power of Attorney. That's just to give it a title. Both of the documents are General Durable Financial Powers of Attorney, but we refer to the supplemental one as the General Durable Financial Power of Attorney. The reason that we use this document in addition to the Maryland statutory form is to cover a few additional powers that are not included in the Maryland statutory form, all of which are part of the counseling that I give to clients as to what those extra powers are and why we recommend providing them. We can fine-tune those extra powers depending on a client's comfort level. But the two together are meant for you to be able to designate another person to be your agent with regard to your assets while you're still alive. This is void at your death, but it's meant for you to give this power and authority to another person to act on your behalf with regard to your assets while you are alive, so that if you become incapacitated, there's no need for court-ordered guardianship. These are a lot more nuanced than I'm able to cover in that very brief summary, but they are vital, and it is part of the conversation that I have with all of my clients. We review these and make sure that they're written in a way that each person is comfortable with. But through the advance directive and the financial powers of attorney, you're doing everything that you can to protect yourself in the risk, protect yourself in the event that you ever become incapacitated. And then there's after death planning. And with regard to after death planning, the two main types of planning devices that we use are either a last will and testament or what's called a revocable living trust. There are many other planning devices available, and depending on your particular circumstances, those may end up being better solutions. But the fundamental plans that are most often utilized are either a last will and testament or a revocable living trust. A last will and testament is, this comes as a surprise to many people, subject to probate. So people often think, well, I have a will, and therefore when I die, what my will says is what will happen, and nothing will have to go through probate. That is not true. First of all, let me say what probate is. Probate is a court process. The probate court oversees the administration of the probate estate. What is the probate estate? It is assets for which there is no living owner and no designated beneficiary. In that event, that asset must go through probate in order to go from the now deceased owner to the new owner. If there is a last will and testament, it is the document that the probate court relies on to know who the new owner should be and how they should own the asset. But having a last will and testament does not avoid probate. It just guides probate. The probate process, because it is the court is involved, it involves filing various pieces of paper and various documents with the probate court to open the estate, to notify the probate court of the inventory of probate assets, to provide to provide the opportunity for creditors to file claims against the estate, and then accountings periodically to notify the probate court what has gone on with these probate assets, what income has been earned, what expenses have been paid, all of that sort of accounting paperwork. Probate on average, we find, usually costs about 4% of the size of the estate. When I say that, really what I mean is that if someone chooses to utilize a last will and testament for their estate plan, then the total cost usually ends up being between the cost of doing the last will and testament plan and then after death having the actual probate process, ends up averaging out to be about 4% of the size of the probate estate. And probate is subject to public oversight, so that's an important point. So frequently, if someone wants to disinherit someone or is worried that they have the risk of litigation from friends or family members or whomever that might bring some sort of challenge to what their will says or to how their estate is handled, it's really better not to allow for public oversight, because that opens the door for someone to be able to cause trouble. And in that event, then it's really important that we talk about how do we avoid probate. So if someone is motivated to avoid probate, the first conversation to have is a revocable living trust, because that is the hallmark of a revocable living trust. It is the avoidance of probate. I have an asterisk here because it's not as simple as it sounds. It doesn't just mean having a revocable trust document. If you have a document that says it's a revocable trust and you signed it and you think you've done everything you need to avoid probate, that's not true. The avoidance of probate only happens if the revocable trust is successfully aligned with all of your assets. That is called funding. Funding means coordinating all of your assets so that they will actually flow in concert with the revocable living trust at your death. And it is only through the combination of the trust document and the asset alignment funding structure that you actually make sure probate will be avoided. A revocable trust avoids probate. It does not give you lifetime creditor or asset protection, nor does it give you any tax savings. So in the beginning, when I was talking about irrevocable trust planning, contemplating planning for a surviving spouse, irrevocable trust planning is different than revocable trust planning. So irrevocable trust planning is something that can be done for the purposes of creditor and asset protection, protecting against the risk of remarriage, taking into account tax avoidance and minimization. That is not what a revocable trust is used for, and it is not what it accomplishes. A revocable trust is done to avoid probate. Irrevocable trusts also avoid probate, but they come with additional benefits, but they also come with some additional consequences, expenses, complications, and that's why that's not the first thing that we go to when we're talking about avoiding probate. We go to the irrevocable trust conversation when we're adding considerations in addition to the avoidance of probate. But the overall cost of trust administration, both from the perspective of creating the trust and funding the trust, and then after death, the administration of the trust, on average, we find that ends up being about 2% of the size of the estate. And that's it for what I have to cover, and I think we've hit our 11 o'clock or later mark. So Jeff, are there any further questions? Jeff, I think you're muted. Okay, well, it sounds like Jeff is having some issues. Well, if you do have any further questions, we'll give Jeff just a minute to be able to see if he can get back into the webinar with me. I apologize. I don't believe that I have the ability to actually see questions that you might be sending through. All right, so we're going to give Jeff just a minute, but please see here that if you do have any questions, I want you to feel absolutely free to email me. I'm delighted to meet with you and discuss the needs that you have and the concerns that you have and what sort of estate plan might be the best in light of your particulars. This presentation is really meant to introduce you to the things that should be part of your thought process and part of the considerations that you take into account and that you discuss with me or your estate planning attorney. Because all of these are relevant considerations. It's just determining what your priorities are and how best to accomplish a plan that will serve those priorities. We'll give Jeff just another minute. Jeff, there you go.
I am here. I apologize, everybody. My computer took an inopportune time to decide to freeze on me. So I apologize for that. I'm going to go into Steve's office and say I need a new computer. So you all will back me up on that. So I sincerely apologize. I want to take just a minute to give Olivia, as we always do, a virtual hand for a job well done. And this is your time to put in those last questions, if there are any. I'm going to check here since I took a quick leave of absence there. It looks like we do have one last one here. So Olivia, the question posed was, so is administration of a revocable trust always cheaper than dealing with probate of a last will and testament?
So I'll give you a lawyer's answer. I can never tell you always. How about that? So the lawyer's answer is that I'm not going to be able to say it is always cheaper to have a revocable trust or a trust of any kind than it is to have a last will and testament that will go through probate. But on average, that is what we find, that on average, implementing a trust and then having the trust administration after your death, on average, does end up costing less overall than having a will and a probate estate take place.
Okay, thank you. So as we wrap up here, if anybody has last questions, now's your time. Just want to share tomorrow, we have Nicole Livingston, one of our senior estate planning attorneys and partners, presenting estate planning essentials, information about wills, trusts, and estate plans. We also have our advisors forum on September 18th, and we do have invitations coming out very soon about that, I promise. Also a really interesting discussion on September 25th, COVID-19 and mental health, and that's going to be presented by a very high-level aging life care manager that we know here at the firm, a friend of the firm, Ms. Ellen Platt. So we think that's going to be a really intriguing discussion that you'll want to tune in for. And our own Olivia is going to be back on October 1st, sharing information about estate planning for business owners. So we'll have invitations coming out about that in the next week or so as well. So please take a couple minutes to fill out our survey. Don't mention the computer freezing. Unless you want to see Steve see that new computer, and provide your feedback. Let us know how we did, thoughts on any additional webinars you'd like to see, and also a great time if you want to meet with Olivia to discuss any planning needs that you may have for yourself or your family as well. We always want to be a resource for you here at the firm. So I'm going to check to see if there's any other questions here at the end, and it looks like we do have one more. The question is, what if trustee and POA duties are too tough? And I'll assume that that might mean too tough for the person that may be serving in those capacities, Olivia.
So that's an excellent question and a realistic question, because it can be a lot of work and it can be a difficult job. Not always, but it can be. And so the reality of that is, number one, when you are making the decision as to whom to designate to have that authority, it's important that you be aware and perhaps even have a conversation with that person as to whether or not whether they feel up to the job, whether they want the job. The other thing that I always recommend is that you make sure that you've named backups. So I always recommend that people have at a minimum 3 named agents or trustees or what have you, in order to make sure that if the person that you've named first just cannot do it, they do have the ability to resign. Just because you've named someone does not mean they have to do it. So if they do feel overwhelmed or cannot manage the job, they resign, you want to make sure you have a backup. So it's always important to name at least 3. And if you have more than that, great. But that's one way that you can help make sure that in the event someone just can't do the job, that they step out of the way and you've got a backup that you've named.
Very good. And one last one, unless there are going to be more. How do you keep it from becoming overcomplicated for those trustees and beneficiaries after death? A little bit of a global question, but if you have any thoughts or comments, Olivia.
Sure. So I think that the best way to minimize that risk that it will be overwhelming or too complicated is to do something that we offer and emphasize. So I always tell clients, I am available for what's termed as a family meeting. That's not always the appropriate term. What it means is, after you've put your estate plan in place, let's have a meeting with the people who are going to be involved in actually carrying it out, so that they're not caught off guard when the time comes. They've been introduced generally. I don't go into details about the specific finances. I don't go into details about the specific numbers, but I give an overview of what the documents are, how they work, how this person or these people will be implicated. And that way they've been introduced to it, they've gotten an initial introduction and education, but perhaps most important, they now know that I'm a human that they can reach out to if they ever have questions, if they ever need help. And that's another thing that I emphasize to avoid it being overly complicated or overwhelming. People should bring in advice from professionals and rely upon us, their attorney, their financial advisor. We are here to help guide you so that it's not overwhelming and too complicated. So having that initial meeting to introduce everyone to what's being put into place, and then emphasizing that I'm here to help along the way. and emphasizing that they should take advantage of that.
Very good. Wise words. All right, it looks like our questions are complete. No, actually one more. Let's see here. Yep, one more. So do revocable living trusts ID asset specifics, and should children have revocable living trust documents?
So the revocable trust document itself, as I do it and as our firm does it, does not include the specific assets. That's different depending on different attorneys and different law firms. We don't do it that way. In my mind, the reason for that and the reason that it's a good idea to not do it that way is because, number one, assets change. And so to have the assets as part of the actual revocable trust document can just lead to some headache and confusion because assets change over time. And so that list of assets can change frequently and drastically. And so we don't include that specifically in the actual document of the revocable trust itself. But if the question is based upon the idea of how will some future trustee or future person who is involved, how will they know what the assets are? This is an excellent question. And this goes to how important it is that you work with an attorney and a financial advisor so that if there is ever a person who steps in to manage things for you, who has no concept of what your assets are or where, they have professionals who have worked with you to whom they can turn, who will have all of that information and be able to help them at that point in time. And that's one of the major incentives in my mind for having a team of advisors made up of your estate planning attorney and a financial advisor and maybe a tax person as well, because that way, if there is ever someone stepping into your shoes and taking care of things for you or after your death, they will have a resource to turn to who will know all of that important information. And then I think the other question was about a copy of the revocable trust being provided.
No, the last part of the question is, should children have those types of documents as well?
So if that question is, should children have their own estate planning documents, my answer is everyone over the age of 18 should have an estate plan. Whether or not it's a revocable trust is just dependent on the conversation that I have with them. But if the question is, should they be given a copy of your revocable trust, that is entirely personal and part of the conversation that I have with clients. The thought process there is providing a copy of the trust document, but that you may later make changes to, that can sometimes lead to confusion. So that's something to just be aware of, that if you're going to provide the documents, you need to make sure to also provide any updates that you make to them. And that's personal to you. What I always tell people is, I don't know that your children want to keep track of your documents. Maybe the best thing is for them to simply know where you're keeping them, and to also know that I have a copy of every single document that you'll sign, so that if they ever need and can't locate yours, that they can always come to me. But whether or not to actually provide them with a copy is part of a deeper conversation that I can have with clients.
Very good. All right, well, thank you everybody for making this a successful webinar. Thank you again to Olivia for a job well done as always. And we look forward to seeing you on another webinar here sometime soon. And hope you all have a wonderful rest of the day and take care. Thank you so much.
Thank you.